Well, welcome everyone to ICAR's annual meeting. This is our fourth and final day of our 2020 virtual meeting. We're so excited to have all of you with us again. And this morning we're going to start with a couple of housekeeping things. We're going to put the housekeeping document in the chat for those of you who haven't had a chance to look at it. If anyone needs any technical support, we have a wonderful technical support team with us, and the contact information for any help you might need is in that document. And so if you need anything from us, there's contact information there. And with that, we have a wonderfully packed and exciting day for us as our final closing day of the ICAR annual meeting. We're going to start, because I know we have a busy schedule this morning, with a panel on mandatory human rights due diligence and the different models and different perspectives from around the world. And for that conversation, I'm going to turn it over to my colleague, Abby Henderson, who's going to introduce us to our panelists and our discussants today and take it from there. So Abby, thank you so much.
Yeah, thanks, David. As he just said, we're really excited to be kicking off the final day of the ICAR annual meeting this year with an awesome panel on mandatory human rights due diligence, or mHREDD. We are hoping to kind of make this panel a bit more of a discussion, so I'll be going back and forth with my fellow discussants. It's probably not surprising to any of you to see a panel featured on human rights due diligence. And for those of you not familiar, the concept of human rights due diligence was established in the UNGPs. This is the process by which companies put their responsibility to respect human rights into practice through identification, prevention, mitigation, and accounting for how they address adverse human rights impacts. And the mandatory aspect is coming into play more and more as we explore different liability regimes that can be enacted to ensure that those things are actually happening inside of companies. And I think, you know, in a normal year, we would have a more, you know, a different conversation about human rights due diligence, but we are kind of coming in a unique time in the world with the COVID-19 crisis, the racial uprisings in the US, and climate change. So what we wanted to explore today is kind of how thinking and messaging might be shifting to meet this moment. And so we're going to do that by exploring the state of play with my fellow discussants that come from a variety of jurisdictions. We're going to discuss how this issue has changed in the last few months and how the advocacy around pushing for these regulations and regulations in different jurisdictions has changed in light of the crises ongoing, and hopefully take some time to get a little bit hopeful about what we really want mHREDD to look like. So very briefly, I wanted to introduce the folks I'm going to be in discussion with today. We have Arnold Kwesi, the coordinator of the Uganda Consortium on Corporate Accountability, which is housed at the Initiative for Social and Economic Rights. We have Fernanda Hoppenheim, the co-executive director of the Project on Organizing, Development, Education, and Research, or PODER, which focuses on corporate accountability and human rights in Latin America. And finally, we have Claudia Sauer, the coordinator of the European Coalition for Corporate Justice, or ECCJ. So to kick it off, I wanted to throw it to my fellow discussants to kind of just give us a snapshot of what is the state of play, what is the thinking around human rights due diligence in your jurisdictions right now. Let's start with Arnold.
Okay, thank you very much, Abby. I hope everybody can hear me. And thanks again for the invitation to be part of the general meeting for the ICAR. In Uganda, it's really, really difficult. I struggle to use even the term, human rights due diligence, because the only times I think it has been used. I think the Uganda Investment Authority used to conduct due diligence on investors, and then political interference came in and they stopped actually doing it because they said it was scaring away investors. So what we've seen currently is that there is a bit of a shift now, and when I say now, it's like from last year, 2019. We had the enactment of the Human Rights Enforcement Act, which makes provision for mandatory due diligence for business and human rights concerns, including, FPIC prior to commencement of all projects. We've also seen, and we've struggled because I was part of the government-led committee developing the National Action Plan on Business and Human Rights, and we really had a huge tussle to put clear wording around mandatory human rights due diligence for all development and investment projects, but it has always been a struggle. We managed to have it in. The document is not yet complete, but it's final approval stages. So that I see a shift of the language having human rights due diligence literally just starting off from like last year. The unfortunate bit, we had also an amendment to the National Environment Management Act, and it was shocking that the whole act that was last year, which was passed, they only changed and added environmental and social impact, but you struggle to find any wording around human rights due diligence in the whole act. So they are still very hesitant around it. But the progression around it is that we, working with the ministry responsible for gender, labor and social development, are now in discussions of working around a new law, which we call the Social Impact Assessment and Accountability Bill, which is supposed to look at broad human rights impact assessment, but also look at critical areas around due diligence of all projects, and makes it a more legal rather than voluntary term, because project developers and all kinds of investments will have to be certified by the ministry under the new proposed law so that they undertake all these. The challenge is a lot of times, and within the environment here, a lot of times due diligence was looked at from an angle of corporate social responsibility rather than accountability. And we had so many situations where development projects and investors spend more time trying to understand what the problem and the needs of the communities are, and then doing, making provisions, either it is scholarships or health facilities or building water sources, rather than looking at the impact the project would have on the communities. So there is a bit of that shift that we're working around, where it is to see concrete steps around human rights due diligence within the policy and legal framework beyond the voluntary undertakings of the the changes have only been seen as far as 2019, but before that we didn't have it. Thank you.
Awesome, thank you, Arnold. Fernanda?
Hi, thank you, Abby, and good morning or afternoon, everyone, or even evening if you're in Asia. It's great to be here, and thanks for the opportunity. Some of the things that Arnold shared resonate with what we see in Latin America in terms of, the advances of the discussion around the actual term of due diligence, right? Or human rights due diligence as such. It's been around in different discussions, but really not as broadly as we would like. In terms of, with the UNGPs and some countries having national action plans or works towards national action plans, there were some discussions around human rights due diligence, but progress is really shy, I would say, in terms of, a potential law, let's say, or including this perspective into regulations. Of course, there are, many countries such as Mexico have mandatory environmental assessments before conceding permits for example, extractive industries or other industries that would affect, large portions of territories and local communities and the environment. So environmental assessments are mandatory in that sense, but in our experience, they are mostly taken as part of, the paperwork a company needs to get done to access those permits. It's not really in discussion or in dialogue with the communities. It's not really an element that would, for example, stop a project because the actual environmental impacts would be huge. It's something that it's part of the different things that companies do to get those concessions or permits to operate. With the what we call structural reforms in 2013 in Mexico, there was an energy reform, and so the law around energy projects, energy generating projects, incorporated for the first time social impact assessments, which don't necessarily have a human rights perspective as such. They're only mandatory for energy generating projects, whether it's fossil fuels or renewable energies. There is no methodology in the law or any specifics on what needs to be contemplated into those social impact assessments. So it's been very, I would say, depending on who is promoting it, who is doing it, it's depending on the company. So it shifts a lot from project to project, and they are not public. So the actual communities don't have access to the social impact assessments to see what exact impacts are being contemplated and what the mitigation measures would be. And then, of course, FPIC, free, prior, and informed consent. I mean, consultations, are done. They're done very poorly, I would say. The way, again, the methodologies, the way consultations are implemented in Latin America, in the countries that are part of the, ILO Convention 169, are not really contemplating the fact that communities might say no, right, to a project. So it's more, again, part of a path to actually get the permits. And it's something that companies generally consider as something they need to get done and get done as fast as possible. And the authorities that implement those consultations, again, don't necessarily have the enough elements or enough experience to get them done properly, and with the highest standards, international standards, and so on. Plus there's corruption and corporate capture dynamics and so on. So it's a very complex context. I would say that one interesting thing that has been happening in the region is that communities, hand in hand with CSOs, are implementing community-led human rights assessments. And Poder was part of one in Puebla, in a state near Mexico City, before a mining project. Well, it's still in the exploratory phase, so the communities had a lot of elements from that assessment to actually fight back this very dangerous project for their lands and the river they live in. And we're conducting another one, and colleagues around in the region are conducting this kind of assessment. So I would say that civil society is sometimes going faster or using better methodologies than the actual regulators or the authorities. And finally, one quick comment. Last week, a week ago, a new project for a law that incorporates the due diligence elements, and it has a kind of complicated name to translate, but it contemplates corporate due diligence, if you will, in terms of human rights, was presented, but we haven't had access in Mexico to Congress, apparently, because it's a tweet, and we don't have access to the actual text of the law. So yet to be seen. They are, I mean, it's supposed to be public, but you click it and it doesn't open. So we've been asking, look, can we get the actual text and see what's contemplated in there? So it could potentially move things forward, but we don't really know what's its content. So yet to be seen. Stay tuned. And I think I'll stop here and share more in the next round. Thank you, Abby.
Awesome. Thank you, Fernanda. Claudia?
Yeah, Thank you very much, Abby, and thanks a lot for the invitation. I'm very happy to be there for my second ICAR annual meeting, this time in a special format, but we do as we can. So yeah, just to give you a bit of insight on what is happening in Europe, or in the EU more specifically. So here, the momentum for mHREDD legislation has really reached a peak. I'm not sure if everybody is familiar with how the EU works. So basically, the European Commission's role is to propose legislation, and then the European Parliament, which is directly elected by European voters, as well as the Council, which is the ensemble of all 27 member states, have to agree on that legislation. So the three of them go together through a negotiation process to agree on a final European directive or regulation or whatever it is. So what is happening now, in April this year, the Commission has announced a legislative initiative on mandatory human rights and environmental due diligence obligations for EU companies. And this proposal is supposed to come out in early 2021. And if we can believe the commissioner who announced it, it will actually include liability and enforcement mechanisms and access to remedy provisions for victims of corporate abuse. So this announcement was a real milestone in the debate. We've been really working towards this for a long time. So we were very excited to see this announcement come out, but obviously it's just an announcement, and we'll have to wait. We'll have to wait to see what is actually what will be proposed in early next year. So what happened at the same time was that the Legal Affairs Committee in the European Parliament started to work on an own initiative report in order to put additional pressure on the Commission to come up with a robust and solid legal proposal. Well, sometimes the European Parliament does that. It comes up with a report by its own initiative to push the Commission to do something. So that's what they did. And finally, at the level of member states, Germany, who currently holds the EU presidency, is pushing the other member states to come up with what they call council conclusions. So that would be a kind of joint document of all member states, in this case, the ministers that are responsible for human rights and social affairs, that would call for a comprehensive EU action plan on business and human rights, ideally including due diligence legislation. So all three institutions, Commission, Parliament, and Council, seem ready to go and have the right mindset to negotiate useful EU law. But obviously it's not that easy. We saw the first draft of the Parliament report coming out, and it does not feature civil liability as a key element. But this is for us a major problem, because without civil liability, there will be no chance for people affected by corporate abuse from European companies to actually and effectively access EU courts. That means the signal that comes now from the European Parliament to the European Commission is weak, and that's unusual, because the normal situation would be that the European Parliament is a lot more ambitious in human rights issues than the Commission. But the final version in the Parliament is still being negotiated, so there will be some amendments, and then there'll be a vote. So there's still some space to get civil liability in. The other but, or words of caution, is within the Council of Member States. The German initiative proves to be a difficult topic, and not all member states are willing to agree to call for an action plan on business and human rights, and even states where we didn't expect that they would block this kind of initiative. So the game is not yet won, and ECCJ, together with a growing number of partners and allies, are trying to put pressure and also to feed legal expertise on the feasibility of civil liability provisions into all the three EU institutions. Because for us, it's really important that the EU directive proposal that will come from the Commission is a strong one and includes civil liability, because once it will be adopted, it has to be transposed or translated into the 27 national jurisdictions of the member states. And the actual enforcement happens at national level. So that's why it's really important to set the benchmark from the start, because the likelihood of member states introducing civil liability when the EU does not clearly require them to do so is very slim. So that's where we are at the moment.
Awesome. Thank you all for each of those overviews. And I'm going to step into my discussant role to just give a kind of brief overview of mHREDD in the United States. So at ICAR, we've been working on, with many of you, on mandatory human rights due diligence for many years. And we see the European style law as, it makes a lot of sense to us. But as we've taken stock of the realities of US politics, which I hope for all of you who are not in the US, you're not following so that you stay sane. But the reality that we're in and the appetites of US lawmakers around corporate accountability have kind of proven to us that that style of law is not very feasible in the US legislative and legal framework. So that's why we've kind of pivoted to a topic that has a model that has been tossed around, and some of our colleagues have written very smart things about in the last several years. But it's this concept of using the Foreign Corrupt Practices Act as a way to induce mHREDD or get closer to achieving mHREDD in the US. And so for those of you not familiar with the Foreign Corrupt Practices Act, it was passed in 1977 in the wake of Watergate to curb corruption and bribery in global business practices. It provides the US Department of Justice, so our kind of federal law enforcement agency, as well as our Securities and Exchange Commission. It gives them the power to hold companies civilly and criminally liable for bribing foreign officials in their business, in the course of their business. It includes two parts. The first is a prohibition on bribery of foreign officials for a business purpose. And the second part is a books and records keeping and compliance program requirement that directs publicly traded companies to accurately account for all of their assets and liabilities, so that these bribes aren't, kind of slipping under the radar and being categorized as other things on balance sheets and what have you. And so the FCPA in itself offered the threat of huge fines and criminal liability. And because of that, and because of strong enforcement of it since its inception, it really has forced a culture shift around bribery and corruption in business practices. And despite, companies saying to the US Congress that they didn't understand how businesses worked, they would never be able to enact these compliance plans, it has shown that with a strong liability and enforcement regime, you can shift cultures. And while there's still bribery and corruption, the FCPA did move the needle a long way. And I think especially in the moment that we're in with mHREDD momentum around the world, that this is a very interesting model because it did kind of force that culture shift all around the world. So we're hoping to use this model in what we're calling an FCPA for human rights, to kind of feed into the momentum that already exists and hopefully force some of that culture shift. So how this would work is using that same threat of high fines and penalties and strong enforcement to induce companies to build compliance or expand compliance regimes that they already have to conduct European style human rights due diligence is what we hope. So it prohibits companies from violating human rights in the course of their business operations. It requires companies to institute a compliance plan, and the due diligence requirements that we have included in the draft legislation that we're working on are modeled after some of the brilliant work from ECCJ and their key elements paper, as well as the French duty of vigilance law. And then it authorizes and incentivizes the US government to investigate allegations of human rights abuse and then levies those high fines and has the potential for criminal charges for violations. And we chose to pursue this model. We know it's unique, you know, especially in the context of this conversation, but this model is really tested and trusted. I think this community has written about and contemplated an Fcpa for human rights for many years. Companies have been subject to this since it was passed in the 70s, and so they're familiar with this model. They understand these consequences, and they've spent lots of money to build compliance plans to root out corruption and bribery. So we think that it's a model they understand and understand how to implement. That kind of combats some of that, you don't understand how businesses work and we could never implement a system like this, because they've already done it. And then in terms of political appetite, US lawmakers, you know, obviously favor something that they have seen work before. And so we've had the direction, you know, as I said, that kind of these more like affirmative disclosure focused models just are not something that seem feasible in the US. And that's something that members of Congress have kind of echoed to us. And as I kind of alluded to, we hope that the passage of an adoption and enforcement of a model like this would lead to harmonization, because it would apply to companies publicly traded in the US. We would hope that laws that are being contemplated and passed in other jurisdictions, particularly in Europe, would kind of have that cross-jurisdictional requirement to conduct these, and we would see that kind of harmonization. And then, and finally, just that we would hope that in the same way there was kind of a rising tide on bribery and corruption and a momentum around that, just that the Fcpa model would also meet that moment and contribute to this rising tide model. So I'll close out on the US part just to say that we acknowledge that this is not the end all be all legislation, but we do think that this could be a huge step forward to establishing corporate liability in the US. And we're excited to work with you all to see this kind of through and to work with you on other pieces of legislation that fill gaps. So now, putting back my moderator hat, I'm curious, before we move on to the next question that I had planned, I wonder, Fernanda, I'd love to hear you speak a little bit to this community-led initiative, because I think, you know, we do see many challenges, which I think almost everyone hinted at, some challenges to achieving mHREDD in their jurisdiction. So I'd be curious to hear a little bit more about the community initiative in Puebla, if you have extra things to share.
Sure, and I'll be quick because I could talk a lot about this. It's a really interesting process. So this tool, it's called Getting It Right, and it was developed by the now extinct Rights and Democracy organization with, and collaboration with Oxfam America, FIDH. Poder has been part of the community of practice for a while, and we're incorporating, more and more groups that are interested in adapting and using the tool. So we kind of took that that model and of course adapted it to the reality of the communities we were going to work with, and we put together a team of to implement the assessment that was composed by some of their members, but also members from the communities, which is kind of an articulation of different rural communities, indigenous communities in the region, in the north of the state of Puebla, and also 2 local organizations that work very closely with the communities. So it was like a combination of forces, if you will, and abilities as well. And we had some scientists collaborating, in terms of, analyzing the environmental part and, the soil and the water and this and that, because the way this methodology works is that the first thing you do is, some workshops or discussion spaces with the communities to define which human rights are, really that could be affected are really their priority concerns, because you could assess a zillion things in this type of evaluations, right? So in the case of Puebla, it was water, health, and the right to a healthy environment, which is part of the American Convention of Human Rights. So it was very interesting to kind of first go through this process of discussion and with the communities, then define the focus of the assessment, and then start to implement the assessment. So many of the phases were actually implemented by community members. They were, serving the state of the health situation in the community. They were participating in different essential parts of the of the process, and it ended up, with a publication that had, put together all of what we found out. And it was also used, so it was followed by an advocacy process with the local authorities, with investors in Canada, because this is a Canadian company operating in Mexico, and so on. So even a delegation traveled to Canada with community members accompanied by Poder and received by local groups in Canada, to kind of talk to Canadian authorities. And it was around the time when the ombudsperson was created, the ombudsperson office was created, and there was hope that something interesting could happen. And so far the project hasn't gone forward, so I guess good things did come out from this process, but it also was a process of strengthening the community articulations, having more elements to understand the actual impact. And it was actually this assessment much more thorough than the one that the company had to do to get their paperwork done, right? So this has been implemented, different adaptations, if you will. I don't know if that's an English word. Anyway, from the methodology has been implemented, in different parts in Latin America, in Chile, in Peru, in Central America, I think Honduras, in South Africa, and I guess in a couple of more cases that I don't have here at the back of my mind, but it's been a very interesting process being part of this community of practice. And I think we've learned a lot in terms of what, this kind of assessments, or even it has given us elements to incorporate to the due diligence discussion, right? What needs to be incorporated in this kind of processes. So, yeah.
Great. Yeah, that's super, super interesting. Thank you. Thank you for sharing more about that. So I'd kind of like to turn back to this concept of momentum. So especially for Arnold and Fernanda, mHREDD seems to have been gaining a lot of traction and attention, particularly political attention in the West, and especially in Europe. How are you all, how are your peers in Latin America and Africa who are thinking about this concept following these developments? And do you anticipate that this momentum is helpful for achieving additional corporate liability or corporate accountability in your work or in the communities that you all work with? Arnold, do you want to take that?
Okay, yeah, thank you. And I think it has a connection to what Fernanda just said, because it was really interesting to hear the whole community-led human rights assessment, what we have seen and what we have been doing, and I will get to the direct question, but what we have been doing is supporting also communities in developing what we call community development agreements, because a lot of times we see investment and development projects that come in, like I indicated at the beginning, with flowery corporate social responsibility, which in essence is just brand enhancement for them, like not really doing a lot, but manipulating the community. So what we see, and a lot of that corporate social responsibility becomes a bit of trade-off. It's like they are doing this good so that they are not being held accountable. And we see it so many times, even local governments fall for it, because we have engaged with government who try to justify an abuse or a violation by a company or a development partner, saying, at least they constructed the road, or at least they have built a school, or they have done, and the argument is always, but that's not their role, that's not their job to do. So when they violate, so on the issues around momentum, is that we're really struggling to get government agencies to understand and appreciate the importance of human rights due diligence and really corporate accountability, because it's such a new area for them to engage in, and so many times they tend to focus on the corporate social responsibility that this company is doing, not looking at all the wrongs or the violations and abuses the company is doing. So because of the failure of the state and its agents to ensure like social services are provided within a community, or to ensure that there is access to remedial mechanisms where there have been abuses, it's very easy for companies to come in, and other development partners, with flowery engagements that manipulate the community. They will build a health center here. They will offer scholarships for education. They will, ensure that there are water sources, in a way that takes away a push for accountability when there are abuses and violations. And so many times communities fall for that kind of narrative, because every time we engage with them, you hear justifications. At least that company does this, this, and this. At least that company has ensured that the community has access to this. And all over time we say, but that is not their job. Community has, and so many times we sit and ask, so if this community or this company next year decides they are not giving scholarships, can you sue them? You can't sue them because it's a voluntary undertaking, yet you need to be holding them accountable. So what we are trying to see, to push, and with the momentum, maybe on the continent, but also in Uganda in particular, is to see how we push this accountability beyond the state, but also looking, and I know, I don't know if it was Claudia that mentioned a bit on the, looking at where these companies are incorporated and the different frameworks that apply, and pushing for things like extraterritorial obligations, and trying to hold corporations wherever they're accountable for abuses and violations, but also working with communities and state and corporate entities to see how, to kind of reinforce the importance of engaging communities and pushing for principles like free, prior, and informed consent, and ensuring that communities are at the heart of everything they're doing, but not really refocusing on corporate social responsibility. For us, that's why we engaged a lot with, government agencies that are very that are responsible for, looking at the social constructs of some of these provisions, but also how they affect the vulnerable and marginalized communities. And so we work closely with the Directorate of Social Accountability within the Ministry of Gender, Human Rights Commission, and Opportunities Commission, looking at these gaps areas and seeing how they can be the reforms can be undertaken, and also restriction measures undertaken where there are abuses and violations. But the other thing that is coming up, and where we see a lot of weakness in the gap, where the large scale multinational corporations or transnational corporations, or even local companies, engage with abusations that are with the chain and value supply, because so many times they are using local actors or small entities that abuse and violate, and then they tend to pull out and say, we are not in control of what they do. And so many times the angle is said, but you benefit in what they do. because if they are producing raw materials or supplying you labor, you cannot reap the benefits and totally not be held responsible for the violations and abuses. So it's a bit of a struggle, especially from the policy and legal framework, because it's very weak, and enforcement-wise, it's a huge challenge. But we're trying to see how to use partners within the government agencies, but also empower communities to self-advocate, because so many times we say we are not on the ground, and so engagements with communities will push for more meaningful due diligence exercises, but also meaningful accountability mechanisms that are put in place beyond what the state and its agencies are providing. Thank you.
Awesome. Fernanda?
Yeah, so I was remembering that right before, like a week before the pandemic, went wild and was declared by the World Health Organization, we were together in Mexico City, actually, in an event on human rights due diligence. And it was an international, mostly focused on the region, but with also international invitees. And I think there was a lot of momentum there. Like, this was gearing up. And then, we went to lockdown for 6 months, and who knows till when, at least in the Americas. There was a lot of, I guess, or there is a lot of interest and push, not necessarily for mandatory due diligence. And I think that's where, the key element is, and the nod of the discussion, if you will. But, the OECD has this project with with resources from the EU, together with the ILO and the UN Working Group on Business and Human Rights, to promote corporate accountability, or they call it responsible business conduct in the region. And there are some resources there, and they supported this event. They were present at the event. There's also, I guess, interest and a lot of thoughtful reflections and contributions from the Inter-American Commission on Human Rights, specifically from the Special Rapporteur on ESCRs, and quite a bit of push, I would say, or from civil society organizations, right? So I think, there's a combination in the region. At least my analysis is that most of the push comes from civil society, and combined with spaces that we share or we create with this international partners, if you will, the multilateral spaces and the multilateral institutions. I would say that in terms of the interest of governments or business associations and so on, of course, there's some reluctancy in some cases, there's lack of experience in some others, or, they are not yet in, I would say, kind of in this momentum as much, or taking advantage of this momentum as much. I also think there's a lot of work and energy around the treaty process in the civil society in Latin America. And that also has some, due diligence elements or prevention elements that are very important. So I see that there is momentum, but it's yet quite unclear in terms of, are we going to go for laws? Are we going to go for the treaty only? What's the best combination of elements that we need, right? Or just, public policy, kind of this, the mildest option of it all, right? So I guess, of course, the developments in Europe influence, what happens here in terms of, there are a lot of investments from European companies in Latin America. It's a very important commercial partner. There's the Mercosur EU agreement that, has been refreshed, if you will, the Mexico EU agreement that has been refreshed, and so on. So there are a lot of, what happens there has an impact here in terms of the investments and how companies behave here, and what elements from those directives or whatever it ends up being, could be used to protect human rights here in Latin America, from potential abuses from European companies. So there are a lot of connections there, and I think of course, and we're going to talk about the crisis in a minute, but of course the pandemic has had an impact on all these initiatives or these movements that were happening. So I guess I'll leave that reflection for the next round.
Great. Yeah, so let's move to that one because we are running short on time, and I could listen to you all talk about what's going on in your jurisdictions for a long time. I think all of this is really interesting. But yeah, let's move into, you know, where does mHRED fit into this kind of conversation of systems change that we're having post, I can't say post COVID-19 yet, but in the COVID-19 context, you know, I think this meeting has just proven to me that there's such an appetite and a realization that the systems that are in place are not really working, and when we need something else. And so I'd love to hear from you all in a bit of a lightning round. How else have these crises affected your thinking around mHRED and how you're advocating for them? Claudia, let's hear from you first.
Yeah, thanks. I think it's a very relevant question, and I'll start with the bad news. mHRED laws alone will not change the system. But the good news is, if they are well done, and if as many jurisdictions as possible had HRDD legislation that includes corporate liability, that could be an excellent starting point to change the economic system. In my perception, at EU and international level, the COVID crisis has accelerated the debate. And even when the commissioner in Europe announced his legislative initiative, he admitted that the pandemic has shown the need for better regulating the economic globalization, and that it has exposed the deplorable working conditions in global South supply chains, and that this was a big motivation for them to actually move forward fast with that file. The Commission, at least on paper, argues that they want to get away from the short-term thinking of corporations and steer towards more sustainable and long-term business models at the Commission. So this is quite a paradigm change for the Commission to really say such a thing and declare its willingness in that direction. And it stems partly also still from the financial crisis that we saw emerging in 2007, 2008, and that revealed already a need for better regulation in many fields. So I think the need for a system change was certainly there before, and through COVID, it has just become more visible. I think also the climate crisis is certainly another driver that indirectly also steered some related EU processes, like better ESG disclosure for corporations and investors, for example. So I think basically our calls would still be the same, but they are supported. Yeah, it's a weird word to use maybe, but yeah, they are supported by more visible urgencies. And I think now is the time to speak to a larger audience and to create more public pressure for doing the right thing, because people are quite sick of things going wrong, I think. So this kind of taking back control of decisions that affect our daily lives, our environment and our economy, that's something to appeal to, and that could create maybe a better momentum or a bigger momentum.
Yeah. Great. Arnold, do you have quick thoughts on that?
Yes, it's you know, we would think, and this is something we've been having discussions with the government, would think that this crisis would be a lesson, but the unfortunate bit, the more things change, the more they remain the same. Like they actually have learned nothing. Regulation, because one of the things that we've been dealing with, especially with private actors involved in social services and business, in a way they were hit by the pandemic. We've had situations where private schools have you know, with the lockdown, they ended up closing permanently and turning their schools into apartments and all kinds of things. We've had private hospitals turning away COVID patients, even at the directive of government, because they say once you're in the media for having a COVID patient in the hospital, then nobody is going to come in for the services. And so you're dealing with a bit of discussion saying, a lot of the discussions that we've been having with governments having to take control of social services, especially like education and health, and not leaving it out to the forces of, you know, private actors in business. And the discussion around private-public partnerships is one of the things that we have continuously been saying, because the lack of the weakness in the framework, policy and legal framework, that does not regulate or set standards for private actors is one of the results. What is one of the issues they are facing now with the pandemic, where the public sector is totally outrun. They are trying to move back to the private sector for a bit of assistance in managing the situation, is meeting a lot of blockage. But also one of the things that we continuously see is the issue, sorry, I'm kind of losing my thought, but the issue around holding private actors accountable, because what we saw, and a lot of the things with due diligence here and regulations are connected with the CSL. We are seeing corporate actors that were, you know, contributing towards the pandemic through government task force, but then laying off staff because they cannot afford to pay their salaries. And we're saying, how does that really gel well with the issue around corporate accountability and ensuring that there is broader social and economic protection for your employees, but also within the community where you operate? And I think this is the gaps we are seeing. And the narrative has been, or what we have continuously said within the government is, there is need to take control of social services, and they cannot be left in the hands of private actors, because a crisis like this totally gets the community way behind, and nobody is actually being held accountable when people are closing schools or hospitals, all kinds of things, and not rendering certain services that the government neglected before the pandemic. Thank you.
Thanks, Arnold. Yeah, I think that Sharon really highlighted this yesterday, talking about, Monday, we had Sharon Burrow of the ITC speaking, and she was talking about how, you know, the lean system, the systems that businesses are seeking to achieve, and they ring out any inefficiencies in their systems. And they've seen these, she highlighted these huge corporations who have absolutely no leeway in the instance of a crisis like the COVID crisis. And so then the only option, you know, they see that they have to resort to are the exploitation of their workers and people down their supply chain. And then they do, you know, use these models of control, which you talked about, Arnold, to say, well, you know, we don't have control over that, so that's not our problem. So yes, thank you for highlighting those. Fernanda, can you go 30 seconds, and then we're going to turn it over to questions really quick.
Well, I'm actually not that hopeful, I guess. I don't know. I'm highly concerned about the things we're seeing, at least in Mexico, and I would say in Latin America. I don't see any like thoughtful, you know, or profound shifts in how things are being led. You know, there's a lot of focus on how we're going to get out of the economic crisis, and I don't think due diligence comes into the minds of any of our governors, you know, governments in the region. And we have so many intersecting crises, you know, the gender-based violence crisis, it's huge now, you know, with the lockdown and all, and even in the streets. And we've had some repression in Mexico City yesterday, and the day before, in, you know, feminist manifestations around sexual rights. And so I'm concerned, to be frank, and I think due diligence should be part of the discussions in terms of the solutions or the systemic changes we want to see. And I think civil society has a bit more clarity there, but I don't see a lot of clarity on the side of governments, and definitely no interest or little interest in in the corporate sector right now amidst the crisis. So yeah, in 30 seconds, not a very hopeful message, but we'll try.
Understandable. Okay, so to wrap us up, we have two special guest questioners who are gonna ask a couple of questions, and then we'll do a round robin to kind of get finished up. We might go a few minutes over. Amelia, can we have you ask your question?
Yeah, hi everyone. Thanks for this. It was really interesting to listen in. I'm Amelia Evans from MSI Integrity. And I have to admit, I have not followed closely the kind of machinations around due diligence. But earlier this year, our organization released a report after looking at multi-stakeholder initiatives for about 10 years and found that, you know, multi-stakeholder initiatives, they're not providing remedy, they're not fit for accountability, they're really great functions around sort of dialogue and learning. And one of the things that was surprising to me in the conversations with a number of the MSIs, including often on record publicly, is that they began to say, look, we agree. We're not here to fulfill these functions. And actually, this is why we are now coming out in favor of mandatory human rights due diligence. So I guess a question, particularly for Claudia, but for all of the panelists, is like a concern I've begun to have is there a risk that mandatory human rights due diligence, if not well structured, could just embed problematic practices? Thinking about social auditing, I'm thinking about, you know, joining an MSI and you join an initiative and that's sort of seen as proof that you've conducted your due diligence, because that's industry practice. And I know that's kind of started to emerge, you know, under the French vigilance law. If you look at a number of the plans that have been published, like we looked recently at Danone, they sort of just list the MSIs as membership. And I know that again, in the sort of leaked version of the mandatory human rights due diligence that came out in German, there was this idea that perhaps there will be a safe harbor provision if you're part of a multi-stakeholder initiative. So how do we make sure this is not just, to use Fernanda's sort of language, becomes just more paperwork? And how does it not embed problematic practices? And then I guess for everybody on the panel, a real question about how do we make sure this is seen as a complement and not a substitute for legal accountability for companies when there's human rights violations that have occurred? How does all of the resourcing and efforts that are going into mandatory due diligence not become a distraction to the kind of that and perhaps that other big important end goal?
Thank you, Amelia. Greg, do you want to pop in? We'll take both cues at the same time.
Sure, thanks. And first of all, thanks and congrats to ICAR on organizing, you know, a pretty amazing 4 days of these annual meetings under unprecedented and difficult circumstances. And thanks very much to the panelists. I'm Greg Rigignon. I'm with Wellspring Philanthropic Fund, and you know, this is an area that we've been engaged in for a while. I guess, you know, my question is similar to Amelia's, but maybe to add a little texture to it and to try to link up the points that Arnold and Fernanda were making to the agenda that Abby and Claudia mentioned. You know, there is this, you know, to address this risk about paperwork being filled out, right? One of the options is to ensure that there is community input at the due diligence stage, right? But there's also this enormous risk that it's a box ticking exercise or a reporting exercise where companies say things that aren't true or simply report that they're not doing much and there's no accountability for it, right? And I know that accountability is a central focus of both the European efforts and the concepts that are being circulated for a Foreign Corrupt Practices Act type approach in the US. But, you know, we also know that that's something that the companies are going to resist, and they're going to resist any effort to actually require them to have meaningful input from communities. So how you know, what's the prospect in the US and in Europe for there to be sort of meaningful input from workers and communities, and to really, you know, what's the prospect, you know, and then similar back to you, Arnold and Fernanda, what would you need to see to really believe that this is something that will shift the power and build power of workers, communities, workers, and, you know, affected people on the ground by these international investments? And, you know, and we can tease that out, you know, we could have a whole sort of half-hour discussion about what different stages of this would look like with, national inward investment due diligence, like Arnold was talking about, as a complement to the European requirements. I don't think we have time for that, but that's ultimately where I think, you want a sort of global system of both on the parent company side and on the inward investment side of complementary due diligence and accountability, as Amelia said, schemes. Anyway, so that's, how do you join those up? How do you ensure that there's a role for communities? And importantly, for the national level advocates, national and regional advocates like PODER, like UCA and its members in Uganda, like all the other really amazing groups in the Global South that are doing the frontline work. What's the opportunity for them to input into these processes?
Awesome, thanks to you both. I think those questions go hand in hand. Let's go Claudia, Fernanda, Arnold, and I'll wrap up.
Yeah, thank you very much for these questions. They are extremely relevant, and I'll just pick out some aspects because we're running short in time. I think for ECCJ, one of the key demands for an efficient HRDD law at EU level, or at any level if you want, is good stakeholder involvement. And stakeholder involvement at eye level, not just something, as Fernanda outlined earlier, companies have to get done, like organize a meeting once a year. It has to be really at eye level, and companies need to prove that they take into account what stakeholders or potentially affected people affected by their operations would tell them. Now, the French law on the duty of vigilance gives a certain role, at least to the trade union representatives in the company. They have a certain role assigned in the design of the vigilance plan of the company. That's a good start. It's still not strong enough, and other stakeholders would need to be involved as well. And I think we shouldn't only rely on the law. I think it's very, very important that civil society across the globe really works together closely and discusses together about the ideal laws and how to engage then in litigation and how to enable people affected to go to court and to do litigation. And then with the non-financial reporting directive in Europe, we've seen that it's so important to have enforcement authorities in place. For the non-financial reporting, we had financial supervisory authorities having to check, in theory, what companies report about their human rights and environmental impact. Of course, they're not trained for that. They're not resourced for that. They have no clue about human rights. They are financial supervisory authorities. So this is really a scenario to be avoided, and we need to make sure that we have good enforcement authorities wherever such laws are enforced. Yes, we heard about this discussion in Germany that they're thinking about exempting companies from any liability or parts of their liability if they are part of a multi-stakeholder initiative. So that's very, very worrying. We'll have next week the high-level event of the German presidency on this topic, well, on the general business and human rights topic, and I'll be sure to raise that point in a way that is understood, that we cannot have safe harbor exemptions like that. And yes, there is a risk if HRDD laws are not well done, that they create a lot of paperwork for the companies, but don't help anybody in the end. That's why for us, it's so important to get civil liability and remedy options in this European debate and back in all the proposals that will be discussed further at European level. I'll leave it at that. There would be lots more to discuss, but yeah, thanks.
Thanks, Claudia. Fernanda?
Yes, a lot to say, but I won't. I just say a few things. So I think, again, in terms of the laws, what Claudia just say about enforcement and implementation, it's essential. I think we're still pretty far away in Latin America in terms of having domestic laws for, mandatory due diligence. But again, there are some initiatives. There is some push from the civil society to get the discussion up to date, if you will, to speed it up. But I think we have other laws that are good in paper, but very poorly implemented. And, enforcement institutions are weak, are not are captured, so we need independent enforcement institutions and regulators that actually do their job, and that's a whole different discussion, right? So so again, we need different elements to combat this capture dynamics, right? I think that part of that is, you know, having a strong you know, articulated civil society that it's actually, you know, holding these people accountable and pushing for better laws and better implementation and international connections. So to your point, Greg, on, you know, civil society and workers, I think we need to have a better dialogue with workers, at least in Latin America or some of our countries. It varies from country to country, but you know, to have a better engagement between, you know, workers, collectives or unions and civil society organizations and affected communities, so that kind of within our sector, if you will, better articulation to push for these initiatives, and also, again, dialogues with, you know, different regions and the possibility to participate to actually fully participate and not just as one box you tick in a set of, you know, in a checklist of things that you need to do. As companies or as states. So yeah, I think I'll leave it there because we don't have more time. Thanks a lot.
Arnold, will you finish up? And if you would, I'd love for you to touch a bit on this question that Corbin put in the Q&A about how even if mHREDD style legislation is passed in other jurisdictions because of Chinese investment in Africa, what are the prospects of curbing human rights abuses where those laws might not reach?
Okay, all right, thank you. And I will also try to keep very short. One of the things that at least Fernanda and Kadi have mentioned are still very critical in our landscape. The issue of enforcement is really, really a huge challenge. And so many times we've really struggled to get even matters before judicial bodies or even quasi-judicial bodies. And where we have had cases dealing with huge multinationals that are in court, that have been in court for the last, one of them has been in court for the last 15 years, that the victims have died, and those that are surviving are begging for any form of settlement because they don't see, because the companies have all these resources to kind of continue pushing a matter. And so we see those challenges. One of the other areas that we have taken, especially around enforcement or holding companies accountable, is trying to follow the money and really trying to engage more with safety guards within, let's say, the international finance institutions conduct, like the World Bank or African Development Bank or IFC. And more, it's very quicker to get a bit of a resolution on some of these issues than going to the system. I'll leave it at that. For the community, meaningful input from communities, we're really struggling to get principles like FPIC into the discussion right from the beginning, telling government agencies and developing all kinds of policies and frameworks that are very critical to say you need to engage with the community before you even start. And what we are trying to push is now, at least for the government-led projects, to say this might not even be the best area for you to put a project. Engage with the community, understand the dynamics of the area, deal with the different interest groups, vulnerable, the women, the youth, the elderly, before. Because what we continuously see is that community discussions and engagements tend to happen when something goes wrong. When there are a bit of disagreements on the project, then they start calling meetings, and the discussion is you need to engage with communities right from the beginning. And what we've done, because so many times we have been looked at as busybodies and economic saboteurs, is now trying to see how we empower communities to self-advocate. They design initiatives, they drive them. We support the process, but we try to be in the background so that the communities are led, and they will meet all kinds of people that are driving the projects. I know we are really short of time, so I'll deal with the question around the Chinese investments. It's a struggle that we've been dealing with on the continent, and one of the issues that it's even challenging talking about human rights in its generality. So imagine going deep to say human rights due diligence and all this was supposed to follow. So the biggest challenge that we have been facing with when it comes to Chinese investments in Uganda or in Africa is that most of these major investments are state-owned. So they're not like where you can literally use their state to hold them accountable. Most of these huge investments from the Chinese government are state-owned. So you're literally struggling to say the government of Uganda or some of the governments on the continent are not willing to give you a platform, because we have had direct conversations where the president says he will bring in the military to protect his investors because civil society are anti-development, and we are just literally raising chaos within the communities to kind of reject investment. So it's a huge struggle. Whereas with different business enterprises or companies, we could say we could engage with their governments. We find a huge problem when it comes to Chinese investments, because most of them are state-owned, and the ones operating at least on the continent are state-owned, either in oil and mining and all these other different large-scale agriculture, farming and stuff. So that is a bit of a challenge, but we're still trying to engage more with empowering communities to push, to kind of rise massively and push for accountability within this, because the government agencies tend not to provide more meaningful remedial measures beyond protecting investors as a way, because we have our whole development plan anchored around creating conducive environments for private actors to do business without, you know, a necessary legislative frameworks that are strong on regulation and standard setting. So that's where the struggle still comes from when you're dealing with some of these massive investment projects. Thank you.
Thank you, Arnold, and thank you all. My only final fast contribution would be, I think these are the key questions, and I think this is stuff we have to keep top of mind as we're developing these, you know, concepts of mHREDD in our respective jurisdictions. I think, you know, the strengths of the Fcpa model are that they have, we've seen in the bribery context at least, that they have driven behavior change. So the kind of strong enforcement and liability, and the ability of firms to say, I cannot engage in human rights abuses because it is illegal and there is too much risk. That is something that is very strong in the Fcpa model. And I saw Charity put in the chat as well, on the civil side, that is something that is not included in the Fcpa model. And due to the political realities, it's not something we're exploring in this exact piece of legislation. But what we hope to do as a steward of this community is continue to work with folks on additional legislation that will build what we hope will be a legal system, not based all in one law that does everything, but in a set of laws that build a strong and robust legal framework in the US. And so I think that's where our thinking is around that piece. And I want to put a plug for one of the sessions, the breakout sessions that is about to happen right now on the community piece. We're going to have an awesome discussion on community-centered business and human rights, rights holder-centered business and human rights. So please join that breakout session if that's something that you all are interested in. And to wrap up, because we're totally late, just thank you to everyone. I'm so encouraged by this community and the forward thinking that's happening in this space. And I hope that, you know, folks like Amelia and Greg keep pushing on these questions that have to be top of mind to build real, robust, and effective legal structures. I think that's number one. We have to do that. If we're not doing that, what are we doing? So thank you to all of our panelists. I'm going to pass it over to my colleague Jenna to give us some instructions.